Today, the U.S. Supreme Court issued its decision in Haaland V Brackeen, upholding the Indian Child Welfare Act in a 7-2 decision. This news is met with sighs of relief all across Indian country. Journalist and Cherokee citizen Rebecca Nagel said, "Today's Supreme Court decision is a victory not just for Native nations and families, but also for the rule of law." The legal challenge threatened to topple a law widely regarded as the gold standard for child welfare, and a ruling striking down ICWA could have severely weakened tribal sovereignty in general. Dan Lewerenz, citizen of the Iowa Tribe of Kansas, is an assistant professor of law at the University of North Dakota School of Law and a former staff attorney at Native American Rights Fund. He said,
"If the court had done what the plaintiffs wanted to do, it would have effectively erased almost every statute ever enacted for the benefit of Indians from the code book. And that's what plaintiffs wanted."
Although the court's decision to uphold ICWA is a victory for natives and tribal sovereignty today, Lewerenz says the fight is not over yet.
Unfortunately, this probably will not be the end of the litigation. The court said that the plaintiffs lacked standing for those equal protection challenges.
Lewerenz says this means the court ultimately didn't answer the question about whether or not Indian statutes in ICWA violate that equal protection.
Just because they lost 7 votes at the Supreme Court doesn't mean they're going to stop. And so we are going to have to keep fighting this. And the next time it might not be on the Indian Child Welfare Act front, it might be some other statute. But the plaintiffs' lawyers and the organizations that supported them, unfortunately, are not going to accept defeat graciously. They are going to be sore losers. They're going to try again.